Calendar. Next category, House bill with a recommendation by the governor. House bill with a recommendation by the governor. House Bill 766 is an act to amend and reenact sections of the Code of Virginia relating to carrying concealed handguns, protective orders. The bill passed the House originally February 3rd. The governor's recommendation has been available and is before the body.
The gentleman from Shenandoah, Mr. Gilbert.
Thank you, Mr. Speaker. Mr. Speaker, ladies and gentlemen of the House, in a moment, I'm going to ask you to reject the governor's recommendation. But before I do, I would like to revisit exactly what this bill was intended to accomplish. Mr. Speaker, this was a measure intended to save lives, to empower people in crisis, specifically women in crisis. I have been struck throughout this process by the extent to which those who purport to advocate on behalf of women in crisis, women in fear, the extent to which they will oppose measures like this because of their underlying philosophical position on firearms. Mr. Speaker, the governor's amendments essentially gut the intention of this bill. It renders the bill almost a meaningless gesture if we adopt the governor's recommendations. For example, Mr. Speaker, it requires the amendments require in-person training in order to be able to avail oneself of the right to carry for a brief time without a permit. We do not even require in-person training, as everyone knows, for regular concealed carry. There are various ways that you can achieve the permit, get the permit without having to have in-person training. I know that's a point of contention with some folks, but we've had no problems in that area, Mr. Speaker, with persons being able to carry lawfully, and they do it every day by the hundreds of thousands without incident. More specifically, I think, and problematic, is the fact that the governor had it apply only to permanent protective orders. Just to remind everybody, and those of you who don't know, there are three types of protective orders in a domestic violence situation. One of them is an emergency protective order, the kind that you get from the magistrate, where in the midst of this crisis, you seek an emergency protective order, or one is issued because an act of a domestic violence has resulted in an arrest. That's only good for a short amount of time, Mr. Speaker, I think 72 hours. And then someone has to go to court and tell the judge that they want to extend that protective order, which is then a preliminary protective order, up until generally the time, if there's an arrest made, that the case is concluded. At that time, the court may well entertain the permanent protective order, but often that is weeks or months after the initial crisis has abated. And domestic violence advocates will tell you that the critical time of danger for any woman trying to leave an abusive situation is the time immediately after they leave. And that is the true moment of volatility, I think, for which this bill was originally intended, the dangerous time. Now, advocates on the other side of the Second Amendment issue, Mr. Speaker, would have you believe that the way to resolve that and solve that problem is to take firearms away from everybody who is subject to an emergency protective order or a preliminary protective order, having never had their day in court. You may recall that part of our agreement with the governor, our broad agreement on firearms and domestic violence this year, contemplated that we would only apply the prohibition on possessing a firearm to those who had had their day in court after a judge after they had had their due process. And that makes sense if we're going to do that way, that folks do have the opportunity to have their day in court, to have a lawyer, to have the case heard. Mr. Speaker, the advocates on the other side would have you believe that taking a gun, telling someone that they might get in trouble if they possess a firearm, is a way to deter them from committing the murder of their family. And that is a fallacy of logic that I've always objected to and always tried to call out for its lack of common sense. That someone who is bent on murdering their wife or their children and then in many instances, killing themselves, is going to be deterred by the fact that they may be subject to yet another misdemeanor or a Class 6 felony for possessing the firearm. What I contend, and what this bill intends to accomplish, is that the only way you truly provide protection for people in this instance is to give them the means to level the playing field. And this is not something that I suggest lightly, and I don't suggest that it's for everybody. And I think the debate centered around this sort of contends that we're going to have people running around willy-nilly with guns who have no expertise or no familiarity, all of a sudden endangering themselves further. But that's not what the bill does. The bill gives them the option, Mr. Speaker, to continue to do what they're already lawfully entitled to do, which is possess a firearm, carry a firearm, but it allows them to be discreet about it. So a woman in this situation who's already in crisis can certainly have a gun in her home already. She can certainly carry a gun wherever she wants already. We're just suggesting that it would be a nice thing if that person could also put it in their pocket or in their purse, so that when they're out and about, if they're somewhere where they, their kid's ball game and they know that their former significant other is going to be there watching them, that they don't have to wear a gun on their hip to discreetly take account of their own personal safety and the safety of their children. So this is not an enormous extension of the rights that folks already have. It just allows someone the comfort at their discretion and at their option to be able to take this dangerous time period and be able to carry in a way that makes sense for them and their family until they can secure the permit through the normal application process. And it doesn't contemplate that they get to do it without a permit ever. It's just for this critical time period that they be able to avail themselves of this right. So the governor's recommendation applied only to the permanent protective order, which again is many weeks or months later, and not to this critical, dangerous time period, Mr. Speaker. So, all we're doing is empowering people to the extent that they choose to be empowered by this. I would ask the body to reject the governor's amendments in that respect. And I thank you, Mr. Speaker.
Gentleman Fairfax, Mr. Simon.
Mr. Speaker, speaking of the governor's amendments.
Gentleman has the floor.
Mr. Speaker, members of the House, we went back and forth over this bill a little bit a few weeks ago, and I raised a number of the concerns that the gentleman from Shenandoah has sort of anticipated here. But what it boiled down to is, I conceded. I think we all agree that we want to save lives, we want to empower people, and we share a concern for protecting the safety of people, petitioners for protective orders, and their families. The concern that I raised at the time, and that many folks on this side of the aisle had at the time that the bill was originally proposed, was that without any training, without any vetting, without any judicial supervision of the process, you actually created the specter, the possibility that you were creating a situation that was less safe, that was more dangerous for people, petitioners, and their families. And we don't have to look very far. I had a list of newspaper articles about young children finding their parents' guns and using them on their brothers, their sisters, their parents. We just heard the other day about a child who found a gun in the back of their car and shot their mother in the back while she was driving down the street. We hear these stories all the time. All the time we said, if only these people had better training about the proper and safe handling of firearms, we wouldn't have to hear these tragic stories over and over again. So, Mr. Speaker, members of the House, the governor's amendments do four basic things. The first thing that the governor does, his amendment, is to limit the scope of this to permanent protective orders, which require a judicial determination, so that there's a judge involved in this process, just like there's a judge in a court involved in issuing any kind of concealed weapons permit. We know there's some supervision of the process. The second thing it does is allows the judge has to certify on the protective order that this protective order will, in fact, be a de facto concealed weapons permit, and the petitioner has to ask for it. They have to want for it to be a concealed carry permit. So it doesn't happen automatically. Because with emergency protective orders, you guys have any idea how many? We actually asked the last time we debated this bill, the delegate from Charlottesville asked, how many of these protective orders are there? There are over 50,000 emergency protective orders issued in any given year. with no judicial supervision. They can be given out very easily. Anybody who wants to carry a concealed weapon without getting a permit could go and file for an emergency protective order. It's granted almost automatically. We'd have 50,000. If we limit this to permanent protective orders, we take that number down by an order of magnitude to about 5,000. The third thing that the governor does is says that the concealed permit to become a concealed, for the protective order to become a de facto concealed weapons permit, they have to have already applied for a concealed handgun permit prior to the issuance of the protective order. Right? This has got to be someone who said, I have thought about it. I decided that I need a concealed weapons permit. I need this to be safe. I've thought about it. I've given some weight to the costs and the benefits, and I'm prepared for that. And then finally, and most importantly, Mr. Speaker, it requires that the person petitioning for the protective order have in-person, hands-on firearms safety training. And, again, that was the biggest concern of folks like me and folks on this side of the aisle, that when you do this, if your goal is, in fact, to increase safety, to protect petitioners and their families in this important time of crisis, that you actually do that. You don't create a situation that makes them less safe. It creates opportunities for accidents. It creates opportunities for unintended consequences. Mr. Speaker, members of the House, we care very, very deeply about the safety of victims of domestic violence on this side of the aisle. I think everyone in this House does. We just have a disagreement about what is the safest way to proceed in these situations. The governor and folks on this side of the aisle think the safest way to proceed is cautiously, in limited circumstances, with judicial supervision and with the appropriate training. That's what the governor's amendments will allow, and I encourage the body to approve the governor's amendments. Thank you, Mr. Speaker.
The gentleman from Virginia Beach, Mr. Davis.
Thank you, Mr. Speaker. I rise to speak to the bill.
Gentleman has the floor.
Thank you. Mr. Speaker, we have a lot of bills that come through this body every year, but there's always a few that stand out. There's a couple of bills that make a real immediate impact on the people of the Commonwealth. And there's a couple of them every year that actually save a person's life. Mr. Speaker, I would contend that this is one of those bills. I can understand the concerns across the aisle about wanting to not do things that make someone less safe. If we wanted to talk about a person shouldn't carry a handgun before they were trained to use a handgun, that could be a valid debate. And maybe someone should, be trained in carrying a handgun when they're of an elevated state because of their emotional state, because they could be being stalked by someone that even the courts perceive poses a dangerous threat. And that's a valid concern, and that's something that we can talk about. But Mr. Speaker, let's talk about only the things that are unique to this piece of legislation. You see, Mr. Speaker, a lady can have a firearm already. She can already carry a firearm without training. She can already carry a firearm while she's in an elevated emotional state. Those things can already exist. And I would argue, Mr. Speaker, that when someone is scared for their life, and they feel they're being stalked by someone that even the courts have deemed poses a violent threat, that they're going to be in that state, and they're probably going to carry that firearm. The only unique thing about this bill, Mr. Speaker, is does that lady, does that woman, does our wife, does our sister, do they have to carry that gun open, or can they carry it concealed? Now, Mr. Speaker, I don't think any of us here believe that carrying an open firearm when we believe someone is stalking us that poses a significant violent threat is a safe thing to do, a smart thing to do, or the right thing to do. But, Mr. Speaker, in the status quo, that's the only option that our sisters and our wives have, is if they're threatened and the courts have deemed that someone poses a significant violent threat, they have to carry open. And that opens the opportunity for that person to walk up and realize one of two things they need to do. Oh, my God. She's carrying open. I better, next time when I come back, I better have a weapon on me, or I need to make sure that I get control of that weapon. And, Mr. Speaker, I think that if we want to protect a woman's life, we need to give them the ability to carry concealed when they're under this type of threat, and I'd ask this body to approve this. Thank you, Mr. Speaker.
Gentleman from Frederick, Mr. Collins.
Speaking to the bill, Mr. Speaker. Never mind, I'll yield. Mr. Speaker, I move to the pending question.
The gentleman from Frederick moves the pending question. Is made in favor of that motion will say aye. Aye. Those opposed, no. Pending questions called for. Shall the governor's recommendations be agreed to? Clerk will close the roll.
Ayes 28, noes 71.
Ayes 28, noes 71. The governor's
Mr. Speaker.
amendments are rejected. House will come to order. Gentleman Shandor.
Mr. Speaker, I move that the bill become law in its enrolled form.
Mr. Speaker.
Gentleman from Charlottesville, Mr. Scott.
Thank you, Mr. Speaker. Parliamentary inquiry.
Gentleman, state it.
I understand the motion the gentleman has made. I would like to know if the bill is passed in its enrolled form, where does it go from there?
Down to the Senate. To the Senate.
It goes to the Senate, right? Yes,
Right.
thank you. Speaking to the motion, I hope that you will oppose the motion. There's really not much more to say. We kind of understand where people are on this, and let's get to the vote. Thank you.
Thank you. Shall the bill pass despite the governor's objections? Clerk will close the roll.
Ayes 66, noes 33.
Ayes 66, noes 33. The motion is agreed to.